You should read the resolution.
Okay. Whereas this Common Council acting as lead agency under the State Environmental Review Act, with the consent of the Town of Alny, issued a positive declaration in furtherance of a resolution of this council dated February 15, 1994, directed the preparation of a draft environmental impact statement for the proposed annexation of premises from the Town of Alny consisting of approximately 36 acres known as the River Glen Mall, after optional scoping and direct filing of a secret positive declaration in according to law. Whereas this council, by resolution dated August 2nd, 1994, accepted the draft EIS for the proposed annexation for purposes of public comment, established a comment period, directing the filing of secret, notice of completion of draft environmental impact statement, and directed the preparation of final environmental impact statement following the comment period and after identification of substantive comments. And whereas the final EIS was prepared and reviewed by the council, which accepted same and authorized the filing of secret notice of completion of final environmental impact statement by resolution dated October 4th, 1994. Whereas in furtherance of aforesaid resolution of October 4th, proposed secret finding statement was prepared in advance of this meeting, circulated to each member of the Common Council for review and consideration, a copy of which is attached hereto. Now therefore be it resolved that the Council, as lead agency, accepts the finding statements in form annexed hereto and made part hereof, and directs that it be executed by the mayor and filed and distributed according to law. Be it further resolved that the mayor and or city attorney shall take such other additional action as may be necessary to further the intent of this resolution, and this resolution shall take effect immediately.
Mr. Dwyer, could you explain this resolution, please?
This resolution authorizes the filing of a finding statement. And if you remember, when I first appeared before you, I explained that the finding statement is the last act in the secret process when a draft environmental impact statement has been prepared. The finding statement says, in essence, that you have fully complied with secret, that you've that you have reviewed all of the potential impacts regarding the annexation, not the construction, because the construction aspect of this has already been reviewed by the Town of Alny. The main issues here for review, if you recall, the EIS and so on, was the capacity of the city to handle sewer and water and provide that service to this area, and also the economic impacts, mainly concerning taxes, reimbursement of taxes, and loss of sales tax revenue. All addressed. Now this is the final act, and the finding statement says, in essence, you go to your next step, which is the consideration of the annexation motion.
Well, you're up to save the second trip. Could you explain the next resolution also?
The second resolution before you is a recitation of the history of the annexation proposal that's been brought forth going back to last year. And if you recall there, you were required under the municipal annexation law to make a decision 90 days after the joint hearing, which was sometime, I think it was January the 20th. And we knew at that particular point that we could never complete the secret process within 90 days. And the city and the town entered into a stipulation stating that the decision on annexation would be postponed until 20 days after the final act in secret. Tonight you're doing the final act in secret, and before you is a resolution and an order which is required by the municipal annexation law authorizing the annexation of this property. There are filing requirements which will take place. Then the town within 20 days from tomorrow, I believe would be when everything would be filed, must make a determination either in favor of or against the proposed annexation. the resolution before you tonight is drawn as if you are in favor of the proposed resolution, and it recites that you have complied with the seeker process. It also recites that this is consistent with the stipulation you entered into with the town regarding the postponement of that 90-day period. If you'd like, I can explain what happens next.
Also want to hear what happens.
Sure.
In the event that either board declines the annexation and the other board approves it, the approving board can commence an Article 78 proceeding and before the Appellate Division, 4th Department, that refers the case to a 3-person panel, including one judge or retired judge of the Supreme Court, to hear the case and hear facts regarding the annexation, the benefits inuring therefrom to the annexing municipality, to the municipality that's losing to the property and to the property itself. And they make a report that's returned to the Appellate Division, and they make an eventual determination on that. We hope that that won't be necessary.
I'll move it.
Second. Alderman Lincoln?
Yes.
Alderman Cheramici?
Yes.
Alderman Weston?
Yes.
Alderman Cavallaro?
Yes.
Alderman Trober? Yes. Alderman Allen?
Yes.
It's carried, Your Honor.
Could you read the next resolution, please?
Whereas a petition pursuant to Article 17 of General Municipal Law and the Municipal Annexation Law was presented to this council of the City of Fulton on November 18, 1993 for the annexation of approximately 36-plus acres in the town of Valney to the City of Fulton. Said territory being described in said petition, a copy of which is annexed hereto and made part hereof as Exhibit A. Whereas upon due notice being published according to law, a joint hearing of this council and the town of Valney was duly held on said petition for annexation according to law, and such cases made and provided at the Town Hall, Town of Valney on January 20th, 1994, at which time all parties interested in the matter were heard and all objections presented. Whereas the aforedescribed proposed annexation and an action under the State Environmental Quality Review Act requiring compliance therewith by each involved municipality, City of Fulton, Town of Valney. Whereas the Town of Valney issued a secret positive declaration on February 10th, 1994, and this council issued a positive declaration on February 15th, 1994, including declaring itself as lead agency. Whereas the Town of Valney, by letter dated May 2nd, 1994, consented to this common council acting as lead agency under SECRA, and thereafter the petitioner for annexation, the Town of Valney, and the City of Fulton entered into a certain stipulation extending the 90-day time period within which the governing board of the City of Fulton and the Town of Valney must make a decision to either approve or disapprove said annexation. And it appearing that said 90 days was insufficient to comply with provisions of SECRA, it being stipulated that such decision would be made by each of the aforesaid governing boards within 20 days after the conclusion of the SECRA process by the city as lead agency, with either the filing of a finding statement or a negative declaration as the case may be. Whereas this council, by prior resolution of this date, has approved the filings and promulgation of SECRA finding statement, making certain required determinations concerning the proposed annexation. Whereas the Common Council has considered the designation of the City of Fulton as an economic development zone in 1994 and the benefits therefrom that would potentially ensure to the benefit of the businesses located in the River Glen Mall proposed for annexation, including 1, wage tax credit for hiring employees and newly created jobs, 2, a power rate discount for electrical service if certain criteria was met, and 3, an investment tax credit under the corporate franchise tax. Whereas the Common Council of the City of Fulton has duly considered the attached petition and the evidence and testimony presented at the hearing on January 20th, 1994, the draft environmental impact statement, the final environmental impact statement, and the findings approved herein this date. Now therefore be it resolved that the Common Council of the City of Fulton finds as follows. 1, that the aforesaid petition for annexation annexed hereto complies in form and content with municipal annexation law. 2, that the proposed annexation of the 36-plus acres described in the petition situated in the town of Valney, County of Oswego, to the City of Fulton, County of Oswego, is in the overall public interest regarding A, the territory proposed to be annexed, B, the City of Fulton as a local government to which the territory is proposed to be annexed, C, the town of Valney as a local government in which the territory is presently situated, and that such annexation will allow the City of Fulton to provide adequate sewer and water facilities without expansion of those facilities compared to the required construction of new facilities by the town of Valney should such proposed annexation not occur. 3, the City of Fulton will benefit from said annexation financially as a result of increased sales tax revenues, which would be lost to both the City of Fulton and the town of Valney should the annexation not occur, and the town of Valney will be reimbursed for in excess of lost real estate taxes by the City of Fulton should such annexation occur without any responsibility for provisions of any services. 4, the designation of the City of Fulton as an environmental development zone enables commercial and retail businesses located on the premises to be eligible for certain economic benefits not otherwise provided if annexation is denied, including a wage tax credit, power rate discount, and an investment tax credit. 5, there shall be no change of school district boundaries as a result of said annexation, and the City of Fulton shall be responsible as primary provider of fire protection, road maintenance, and other similar services. Now, therefore, it is ordered that the consent and approval of the Common Council of the City of Fulton is hereby given to the annexation of the territory now situated in the town of Valney and described in the aforesaid petition attached hereto and made part as Exhibit A to the City of Fulton after this Common Council has complied with and concluded the requirements of SECRA.
I'll move it.
Second.
Do a roll call.
Yes. Alderman Lincoln.
Yes.
I had a question, just wondering. Excuse me. Item 4 there, the designation of the EDC. By virtue of annexation, do we have to go and extend a new boundary, or is it already automatic for the EDC?
We would have to extend the
We
time.
would have to extend.
The EDC boundary.
Right.
Alderman Tiramichi.
Yes.
Alderman Weston.
Yes.
Alderman Cavallaro.
Yes.
Alderman Trowbridge.
Yes.
Alderman Allen.
Yes.
It's carried, Your Honor.
Show your papers, ready?
I think so. Thank you. Resolved that a proposal from the City of Fulton for an agreement to board dogs from the City Animal Control Department at the Valney Dog Kennel be submitted to the Valney Town Board for acceptance as follows. 1, the city and the town enter into an agreement whereby the town will provide their shelter to the city for an annual cost of $4,000. The city will provide food for its own animals. 2, the town will have preference in the use of the shelter. If the unlikely situation of the shelter becoming overcrowded occurs, the city will make other arrangements for their dogs until room becomes available to them again. The city picks up an average of 100 dogs per year. 3, it will be the responsibility of the Fulton Dog Control Officer to handle all of Fulton's animals. The town is responsible for boarding only. Dogs will be boarded and removed per the requirements of the agriculture and markets laws of the state of New York. 4, the city will provide all transportation of its own dogs. 5, the city will be responsible for the euthanization and/or any medical expenses for Fulton dogs. 6, the city will be allowed access to the Valney shelter for the purpose of the placing or removal of its dogs. 7, the city will provide any and all required paperwork pertaining to the dogs placed in the shelter to the town. 8, this agreement will become effective immediately upon the approval of both the town board and the city common council. 9, this agreement is valid for 1 year from the date of approval with review for renewal from year to year.
Is review for renewal?
That is right.
All right.
Means you're going to review it year to year. Well, it's going to be.
I think Alderman Weston, I think Alderman Allen, both have been to the dog
Right.
facility. Do you want to talk
Sure.
about the need for this?
I know that Alderman Allen went in the spring to view both facilities, and I had the opportunity yesterday to talk to both animal control officers and to tour both facilities. I found that the Volney facility was more than adequate, an excellent facility. The animal control officer takes very good care of the facility and very good care of the animals. When I was there yesterday, he had just one dog there, and they have room for, they have 14 cubicles that they can use. So as far as I was concerned, I thought it was an excellent facility, and if it's an opportunity for us to share services and to split the cost of operating, I think it'd be an excellent idea. I've visited our dog pound several times, but I would just add that I was present when the town of Alny discussed this proposal, and they have objections and or stipulations to be done on this. So, however, I see nothing wrong with this.
I would concur. I was at the same meeting, and I guess one of the problems was from a few of the council members there was the cost involved. They thought the $4,000 wasn't enough money. But my point of view is on it, I mean, it's revenue for the town, so, you know, they ought to be willing to accept this. $4,000 is a fair estimate, I guess, as to, you know, how we can take care of our dogs. And for the town to refuse $4,000 in revenue, you know, there's not much more I can say to that.
Didn't, this was not the original draft of this
Yes,
agreement?
this is the one they had.
Is this exactly the
Yeah.
one?
Yeah.
Okay, I thought this one had a couple of changes at the bottom.
I haven't noticed it.
No, I didn't see that. I didn't have a copy of the original.
Yeah.
I saw it.
Looks like basically what they had. I think one of their objections was because the kennel's location to residences, and they're worried about the increased noise and so forth.
Somebody want to offer this? I do.
But I think that they built that with the intention probably of having all the stalls used. So that negates that question.
Somebody want, I'm sorry, Liz.
I said this is renewable year to year.
This is the first time.
But after the first year, if all goes well, assumingly, he's not another $100 every year, he can renew it.
Well, it would have to be agreed to by both parties.
Oh, sure.
They may not want to do it for some reason, or the city may not.
There, it's not like this is 1 year only, and then after that, forget it, no matter how well.
Well, I think it's a trial right now. You don't really know how it's going to work. I don't think it'd be prudent to go any more than a year at this point.
Right, but if all goes well, you can't come out and keep on and say, well, forget it, we don't want you to know anymore. If there's no problems, there's no complaints.
There's no problem unless they get into an overcrowded situation.
The animal control officer seemed to indicate to me that he didn't think there would be any overcrowding. He felt he had the facility to handle whatever animals that we might have pulled.
Offered by Mr. Allen. Does somebody want to second?
I'll second it.
On the motion, all in favor?
Aye.
Any opposed? Motion carries.
Resolved that Chapter 165-61, Schedule 17 of the Vehicle and Traffic Ordinance, City of Fulton, New York, entitled Parking Prohibited at Certain Hours, be amended to read as follows. Broadwell Ave, west side, 7 a.m., 3 p.m., Monday through Friday. Location from Oak Street to Chestnut Street. Chestnut Street, both sides, 7 a.m., 3 p.m., Monday through Friday, from West 4th Street to William Giller Drive. Dennishay Place, west side, 7 a.m. to 3 p.m., Monday through Friday, from Chestnut Street to Cedar Street. Park Ave on west side, 7 a.m. to 3 p.m., Monday through Friday, from Oak Street to Chestnut Street.
District Chairman Ritchie introduced this resolution. I think this is the result of the problems at the school.
Right. I'm not reading this resolution correctly. The idea was to repeal the ordinance that prohibited parking during these hours. Is that the way, am I reading this right?
Delete.
On the top, Jim, says delete from the top of the name of street.
Oh, sorry, I didn't see that. Thank you. Precisely. Last year there was the construction going on at the high school area and overflow parking around the streets in and around the high school, these streets, in fact, and we asked to put restricted time parking there. I canvassed the neighborhood once again at the request of a few residents, and 100% of those canvassed were asking to remove this restriction at this time. I would move it.
I'll second it.
On the motion, all in favor?
Aye.
Aye.
Any opposed? Motion carried.
Motion to adjourn into executive session pending litigation annexation.
I'll move it.
I'll second it.
On the motion, all in favor?
Aye.
Any opposed? For the benefit of the press, we will do no other business except that, and I should forewarn you, and if we do it, I will let you know, that we might just schedule a public hearing, which would occur in November.
Can we get copies of the first two resolutions? They weren't in our packet. Nice.
Sure, here's Joe, yes.
Can we have copies of the first two resolutions tonight?
Yeah. Okay.
So you are or you aren't going to take action on the litigation?
We would take no action except that we might come back out and schedule a public hearing.
Will it take very long, do you think, to discuss this?
Our discussions, I truly don't know how long they'll go. We will conduct no other business except that, and if we do come back to order, the only thing it will be is to schedule a public hearing for the first meeting in November.
Okay.
That's the only thing. Okay?
Are you going to go there? Oh, yeah.
Well, that's why I said it would hurt if it was same old stuff.